We can get started.
Thank you, Your Honor. My name is Anthony Pearson. On behalf of the Attorney General's Office, I represent the state of Ohio.
Thank you.
You want to call the case number, Your Honor?
Which is, I believe it's 21 CR 451, State of Ohio versus Adam Coy.
Thank you. And who address the charges?
I'm sorry.
She wants to read off the charges.
Oh, I'm sorry. One count of murder, unclassified felony, one count of felonious assault, a felony in the second degree, and 2 counts of dereliction of duty, both misdemeanors in the second degree, Your Honor.
Okay, thank you.
Good afternoon, Your Honor. May it please the court. I'm Mark Collins, 006-1207.
And I'm Caitlin Stevens, Your Honor, 0095589.
Both of us today are on behalf of Mr. Adam Coy. Adam, can you hear us?
Yes, sir, I can.
Previously, you gave me permission to sign your name to the not guilty form, as well as the agreement to have your presence waived and go forward with the video conferencing today, correct?
Absolutely, and thank you.
If I may continue, Your Honor, we would waive a reading of the indictment, accept service of it, acknowledge an arrest date of February the 3rd, Your Honor. We would enter a general not guilty jury demand, and at the appropriate time would be like to be heard in terms of bond, Your Honor.
You may.
Thank you very much, Your Honor. As the court's well aware, there's 2 main components that the court has to address with regards to Criminal Rule 46. The first being, Your Honor, to assure someone's appearance at court. The second with a general public safety concept. In addressing the first one, Your Honor, to assure someone's appearance at court, my client has no record in any way, shape, or form, Your Honor. My client voluntarily did a walkthrough at the scene on December 22nd, Your Honor. My client, in addition, gave a voluntary statement to the authorities, and then my client voluntarily met with the BCI agents for about a 2-hour and 15-minute interview. In addition, Your Honor, he was asked to turn himself in at an appropriate place and time, in which he voluntarily did that. So everything that we've asked of him since December 22nd, Your Honor, he has done. In addition, when he was employed by the Columbus Police Department, he was required to go to a psychologist. He did that as well, Your Honor. In addition, Your Honor, we have his passport if the court would deem that, but it's clear that he's not a flight risk, Your Honor, and that he will appear for every and all court appearances, Your Honor, as so far he has exemplified since December 22nd. The second component, Your Honor, in terms of the public safety as a general component, the court is under Criminal Rule 46, is asked to look at a couple components. The first component we'd like to address, Your Honor, is the history and characteristics of Mr. Coy. He's 44 years old, Your Honor. He's a lifelong Central Ohio member, born and raised there. He's married, Your Honor, for 21 years. He has 3 children. He's very active in his community. He has many, many relatives in his surrounding community. In addition, Your Honor, once he graduated high school, he attended entered the military. 5 years in the Army, Your Honor. He rose to the rank of sergeant and was honorably discharged. He was a member of the military police. After that, Your Honor, he entered the Delaware County Sheriff's Department for 1 year. Then the last 19 years, he's been employed at the Columbus Police Department, Your Honor. In terms of the second component, Your Honor, the court is guided to look at the nature and circumstances of this individual case. And that's important for this case, Your Honor, because these cases are unique. They're like no other cases that you normally preside over upon arraignments. And that they're unique, Your Honor, because this is not a whodunit or anything of that nature. It's simply whether or not our client was justified in using the force he did, and that will be determined, Your Honor, with a jury. So they're unique, Your Honor, because he's not arrested at the scene. As opposed, on December 22nd, he actually had to walk the BCI agents there. So it's a process that normally happens in these types of cases, Your Honor. Examples, he's not a threat, Your Honor. Sometimes it could be a threat to the community. Sometimes the government might ask for a high bond based on potential threat. He's not a threat today, Your Honor. He wasn't a threat today when he met with the agents. He wasn't a threat when he walked them through. He has not been a threat in each and every doctor's appointment he's gone to in his interaction in the community. He has no access to guns, Your Honor. He has been terminated from his employment at the Columbus Police Department. So this unique situation of an on-duty use of force is not likely to happen again. Of course, he doesn't have a prior record, not on bond or anything of that nature, that the other factors to look at. Your Honor, we're asking for a reasonable bond be set today. And what the court might ask would be a reasonable bond. We've done several of these cases, Your Honor. I've had bonds from $25,000 to $100,000 in police shootings in Pike County and other aspects. Your Honor, we also did some research with regards to other national cases because they are unique. Anywhere from $75,000 to $500,000 surety bonds are normally what are put in place because of this separate process. Your Honor, the closest thing this court normally comes to in cases like this is a self-defense case. Various self-defense cases that are currently in the system that we actually represent, Your Honor. We have bonds, people who are out on bond, anywhere from $25,000 to $250,000. And again, the only aspect in this case, Your Honor, is to determine whether or not the force that was used was reasonable or not viewed through the eyes of a reasonable police officer. And ultimately, a jury will determine that. Based on all those factors, Your Honor, we're requesting a reasonable bond. If the court has any other questions for us, we're happy to answer.
Okay, thank you. Brief call.
Today's case, Your Honor.
Okay, thank you.
May I just respond, Your Honor?
Yes, you may.
Thank you, Your Honor. The difference, the state feels that the difference between those prior, I guess, goodwill things by Adam Coy and today is that today he is indicted for a felony, multiple felonies. He's indicted for murder, and as you well know, the sentence for murder is a life sentence. So you can imagine that someone who is faced with that may have ideas of not coming to court. So that is the difference between his prior corroboration and where we stand today. Mr. Collins did talk about prior instances of bonds and other cases. However, bonds have been higher in other national cases. They've been in the $1 million range in other cases. This is unique to Franklin County. We don't see this very often, admittedly, but it did happen and a man lost his life who shouldn't. As a result, Your Honor, the state is asking for a high bond in this case. Thank you.
If I may, Your Honor. I understand what Mr. Pearson's putting forth to the court, Your Honor. However, it's mandatory that all police shootings in Franklin County get presented to a grand jury. My client knew this case was going to be presented the entire time. So the concept that now because probable cause has been found will lead him somehow to flee or something of that nature or be a threat to the community really is incredible, Your Honor. The court can put conditions on him, reporting, phone reporting, in-person reporting, things of that nature that can monitor the situation for that aspect, Your Honor.
Thank you. Anything else by either side?
In any bond that the court sets, the state would like a no contact order between the defendant and other witnesses to this case, including other officers.
Absolutely, Your Honor, and absolutely. And for the record, Your Honor, before we leave, I want to reach out to your courthouse administrator. She's done an outstanding job of setting this up, and we appreciate the courtesy that the court's given us.
Okay. All right, sir, I'm accepting your not guilty plea. I've considered the arguments by both sides with respect to bond. I am setting bond at $3 million short of your appearance, $20,000 recog. And as a further condition of bond, defendant shall have no contact and stay away from any of the witnesses or addresses identified in the indictment. Also, defendant shall have no contact with other police officers for the request. Thank you.
Your Honor, would the court consider the $3 million value, or maybe put on the record the components for that make up the $3 million, just so we have that for the next hearing?
I'm sorry?
Would the court consider lower than the $3 million, or if not, would you put on the record some of the concepts as to why you picked the $3 million?
You know, that is based on everything that I've heard. That is the bond that I've set. If you wish to address it with the assigned judge, duty judge, feel free.
Appreciate that, Your Honor. Thank you very much, Your Honor.
Thank you, Your Honor.
Thanks, Andy.